I'll call the meeting to order. Roll call, please.
Commissioner C.
Here.
Commissioner McBride.
Here.
And Chair Johnston.
Here. Okay, we have an agenda review. Linda, do we do that with you? Is the item 10 letter received from District Attorney that submitted to the board on April materials were received? Motion approved. Okay. Do we need to do...
Well, Chair, are we looking at the current agenda?
Yeah.
So the next step is
As
the
we're looking at
elections and...
item number 3, how does that play into it? We go to approval of minutes after that, or?
That's just
Yes.
special meeting. You have.
Oh, pardon me, that's the, oh, I'm looking at the wrong agenda. Okay. That's identical to the one on the panel.
There you
Okay, here we are. Oh, my goodness. Good news. We have an election. So we need to elect a chair. Do I hear nominations?
I think the vice chair.
I think that's an excellent idea. I second that motion.
I think we ought to keep the same office.
Well,
I'll second that one.
you want to stay the course? No, I think we need to, hope and change. Okay, well then, should we take a vote on the first motion?
You're the chair.
I am the chair. Okay, the motion is that Mr. C be the chair for the coming year. I assume that's for the coming year, or is there a term that goes longer than that?
It's annual.
Annual. See, it's not that bad, Frank. Okay.
One meeting here.
Yeah. And sometimes they don't even meet during that year.
That's-
Okay, so all those in favor say aye. No secret ballot. Aye. The chair declares Mr. C the chair. And I think as the new chair, you get to conduct the election for the vice chair.
Okay. Do we have any nominations for the vice chair?
I nominate Mr. McBride.
Second.
Okay. I move the nominations be closed.
Second.
Okay.
All right. All in favor of the motion?
Aye.
Aye. You're abstaining?
I said aye.
Oh, okay.
Good. I like that self-confidence.
Well,
All right.
Pass the gavel. Ceremony is important.
Excuse me. That's just it.
Right.
All right, we're at item number 5. Review.
Yes. Good morning, Commissioners. And congratulations, Chair C.
Thank you.
There are 3 minor revisions to the agenda this morning. Item 8.0 is updated to reflect 2 additional matters for a total of 9 received for the 2012 presidential general election. Number 2, with respect to items 9 and 10, the investigating attorney submitted a memorandum dated November 1st, 2012 for your Commission's review. And finally, item 13.0C is updated to include a total of 9 matters received for the current election cycle. Thank you.
I'm sorry, the last one, I don't think I heard.
13.0C.
Okay. Got it. All right. Is there a motion to...
second.
All right, item number 7. Oh, and I'm sorry. Number 6, approval of the minutes for April 21st, 2011. Second. All in favor? Aye.
I wasn't there, I'm saying.
Gotcha. All right. Any commission member or staff comments?
No comments.
Mr. McBride?
No comment.
No comment. All right. Number 8, the informational agenda. Receive staff's report regarding 9 new matters referred to the initial complaint review attorney.
Yes.
Motion to receive and file?
This is an informational action. This is an informational agenda item. In the current presidential general election cycle, as of October 31st, staff has received a total of 9 reports and has been forwarded to the initial review complaint attorney, and those 9 cases are currently pending review.
Mr. Chair, I have a concern about the timing on all this. Could you or maybe council walk through the timing and when we can expect these to either get resolved or come to us? It's based on numbers 9 and 10 today, items 9 and 10 that have been here, seems like, for 2 years or more.
I'd be happy to do that. Due to timing issues in the past, when the Board of Supervisors last amended the ordinance, they updated the time limits and made them uniform. It's now 30 days for the initial complaint review attorney. Richard Norman currently serves in that capacity to issue his initial report, either recommending dismissal of a complaint or a report of apparent violation that comes from the elections official. And in our case, these new ones, 8 of the 9 are from the, I believe 8 of the 9 are from the elections official. No, there are maybe 2 complaints.
7 of the 9.
7 of the 9, and 2 are actual complaints from other parties. And after his report, he either recommends back to your commission to dismiss the matter or recommends, and it's referred to the investigating attorney, who's currently Craig Steele. The ordinance was beefed up to provide a deadline for Mr. Steele to finish his work. And so currently you have on your agenda later items that have lingered since the 2010 election cycle. And the hope is that now, with that uniform deadline, I think it's 60 days in his case, those will be resolved more timely.
So in theory, you're looking at 90 days plus some that they should get, we should receive them for resolution.
The investigating attorney has the option of working out a settlement, or will actually have to prosecute it before you, which will involve setting a hearing date and extending that time. So 90 days or less is the optimistic view. If there's a settlement, if there were a quick report by the initial complaint review attorney and a quick settlement, it could be done in a matter of a couple months, but normally it's going to be 90 to probably 120 or 150 days.
Okay, thank you.
I'm sorry, where are we? Mr. Ex-Chair, do you usually handle that? All right. So we have a speaker card for number 8, Mr. Don Becker.
Thank you very much. I am Don Becker, a resident here in the county of Ventura. And so I'd say good morning to you, the chair, and to the other members of the commission.
Welcome, Mr. Becker.
And my observation is along the lines of what Commissioner McBride was just speaking to. And it sounds like, based on the response, that maybe this is the wrong body for me to be presenting my observations, and that is I'm a little dismayed that these complaints, once filed, are not considered really until after the election is held, and so any impact that it might have on the election is null and void. And it just seems to me that this is an important point that the people who are going to vote for these various candidates ought to know about. They ought to know if there is actually a violation, or if there isn't, they ought to know that too. And so it just seems to me that the logistics of this whole operation are incorrect, and they should be changed so that a report and a recommendation, a consideration by your commission could be made in a timely fashion. And as I say, I'm disappointed that that's not the case. And to look on the agenda and to see items from 2010, I mean, frankly, what's the point? I don't, there may be a point, but it seems fairly moot as far as I can see. So, thank you very much.
Thank you for your comments. Okay, I don't have any other dispute cards on number 8.
Chair, if I could make a correction. Two comments I want to make in response to that. First of all, I was wrong about the 60 days. It's 30 and 30 days. In 1296C, the investigating attorney also has only 30 days. And the other comment is, if there were an error that was committed early in a campaign and a complaint was lodged, that possibly could be resolved before the election, or if there was a complaint from the primary, that might be heard by you before the general. If that candidate's in the general, that would still be timely, but it is the timeline established by the Board of Supervisors for these, not by your body.
You know, I recall reading the sections dealing with the time limitations, and for the initial complaint review, there's a 30-day limitations based upon the decision made by the initial complaint review attorney. On the 60-day, it sounded to me, and I don't have that section in front of me, unfortunately, it sounded to me like a written report was required, but only if there was a resolution at that point in time, and the direction or inference seems to be that the matter would be referred to the attorney for negotiation of possible settlements and so forth. And I didn't see a time cap on that. Is
That's the one with the
days?
60 days.
Yeah.
And that's in D. If the voluntary settlement is reached, the investigating attorney shall submit to the commission within 60 days of his receipt of the complaint, so 30 plus 30, that settlement. And otherwise, then it's set and agendized to be prosecuted.
Okay, so there is no written report required by the investigating attorney within any time period.
Well, there are two deadlines. One is if he's recommending dismissal, that's 30 days.
Yes.
And then if he achieves a settlement, 60 days. But if neither of those is done, it has to be agendized, and we could agendize that as staff for a hearing.
All right.
It says in D, if no proposed voluntary settlement agreement is reached, then the investigating attorney shall set the matter for an evidentiary hearing before the commission and shall present to the commission at the hearing the evidence supporting the charges.
That means it takes 60 days to get it.
At a minimum.
6 months to get a settlement. What's to prevent him from taking 6 months to work out a settlement?
They have to have that report in within 60 days.
If they achieve one.
And if not, then they have to set it for a hearing.
But no given time limit on the setting of that hearing.
I think staff, we can control that.
So basically,
If the 60 days expires-
He then notifies staff that there's no resolution, and staff could set the hearing a week late, 2 weeks late, whatever.
Well, there's a whole hearing procedure in your operating procedures, and there's not formal discovery and stuff, but there are steps that would have to be set on a timeline for that, because it's essentially a criminal hearing. I mean, you're issuing penalties and sanctions at the end of it. And they're entitled to representation and witnesses.
What's the fastest that we could actually have a hearing from the filing of the complaint?
I'd have to
How
look
rapidly
back
can
and
that be?
see, but some of the ones were resolved within a year of the complaints being filed the last time. I mean, we had several matters on. It was only these 2 out of 12? I can't remember.
At the time in the 2010 cycle, we have a total of 6 cases. Of the 6 cases, your commission took action on 4. As you will see in the latter part of this report, in item 13, kind of highlights what were some of the final recommendations and action taken by your commission. But there are remaining 2 outstanding cases from the 2010, at which point the investigating attorney has challenges in terms of reaching out to the respondent. And as you can see in the memo submitted, item 9 and 10, it reflect the discussion he recently had with counsel of the respondent. We're hopeful that within the next 2 weeks or so, that there will be some kind of a final recommendation from the investigating attorney, at which point staff will have to come back to your commission with his recommendation. Concurrent to the 2010 leading up to the 2012, we're also working with the new ordinance. So the 9 items that is in the current cycle were reflected back in October 15th. So we're still, the investigating attorney, the initial complaint review attorney has until November 15 to come back with some kind of a recommendations on, the first case was October 15. As you can see, the date file. I'm hopeful that by springtime we would be able to come back to your commission with some final resolutions on all of these cases.
All right, do we need a motion then to receive and file the informational agenda? Yes. Right. Do I have such a move? Okay. All in favor? Aye.
I would like to make just a brief comment. I think what Mr. Becker is saying is significant as to what the purpose of the process is. If the due process takes it so outside the cycle of elections as to, be more political than legal in the sense of our reviews. This is talking about just clearing up the paperwork, but has nothing to do with the sort of the substance of the case. So I guess that should be addressed to the Board of Supervisors as to what they hope to achieve.
Certainly the expectation of complainants who are also candidates is that they will get some relief or some impact from having filed the complaint in the election cycle to which they have complained. It does seem entirely unsatisfactory to have something hanging over from the 2010 election cycle.
But, from the standpoint of the person who is aggrieved or disadvantaged by whatever they're complaining about, but on the other hand, as a tactic to muddy the waters or to provide newspaper quotes is disturbing.
Okay. Item number 9, review, discuss, and take appropriate action on investigating attorney's recommendations. I understand there's some additional information from our investigating attorney.
Yes, the investigating attorney submitted to your commission a memorandum dated November 1st, and you should have that at your desk or your table. He's requesting and recommend that your commission take no action and continue both items until future meeting of the commission. As shared with you earlier, he recently was in contact with a representative on behalf of the respondent, and he believed that he needed additional time to discuss and to reach a resolution. And Mr. Steele indicated that he hoped to have a staff report to your commission staff soon.
Well, at the time that the complaint investigation attorney is appointed, he becomes the petitioner and is a party to the action. I'm a little bit curious about why he has not filed a written opposition or written response to the petitioner's contentions. Perhaps counsel can enlighten me about the addressing the constitutional issues raised by the petitioner or by the respondent.
I'm not aware of any of that. My only knowledge, and which is secondhand, is that sometime after the campaign ended, the attorney left, the respondent's attorney left his firm and was not able to be contacted. I know that when I tried, his state bar information was wrong, and Michael Houston. His state bar information was wrong, and we couldn't contact him directly. And my understanding from Ms. Lee is that he was contacted finally about a week or two ago by Mr. Steele, and that he asked for more time before they could meet and try to resolve it. But I don't know why no response was made, or if a response was made that we haven't been copied on to the respondent's constitutional arguments. I do recall Mr. Steele saying that he wanted to deal with those and present them to your commission, and I think that even came up at a prior meeting of your commission when this was on for status update.
I couldn't find my notes on that meeting. That's the
April.
April 21st, 2011 meeting. I know we discussed the matter, but I don't think we discussed the legal issues at that point in time. There was a reference to referring the matter back to Mr. Steele for negotiations concerning the resolution of it, but I've never seen or heard any response to the constitutional issues raised by Mr. Houston.
Nor have I.
Would it be appropriate for the commission to request from petitioner a written response?
Certainly.
Surely.
Within your purview.
Any feelings about that?
It does seem like at least moving something forward, isn't
I need a motion for that.
it? Okay, I'll move it.
Got a second?
Yeah. You're saying you want a response from
From,
petitioner?
yeah, from
Mr. Steele?
Steele
Steele.
to the letter of Lieutenant Tucker, Mr. Houston.
I assume I assume that that's what we would have today. Obviously, it's been delayed, but I thought that's what we were going to receive today when he came. But I second that motion.
All right. All in favor? Aye. All right, the motion carries. Now, we need to address the underlying issue of the request for a continuance. Any comments or observations there? First of all, let me ask the staff, did he indicate what kind of a continuance he wanted? What much time?
Mr. Steele had a conversation with Mr. Houston earlier this week, and they were able to came to some kind of an agreement that will be working out some kind of a resolution by the end of this week or next week. That was reported to me directly by Mr. Steele. I don't have any knowledge as to the outcome of the resolutions, or there will be any additional steps, or this is going to be a final recommendation. I cannot report that.
So, I'm sorry, do we have a recommendation?
Well, I'm just wondering, I really would like to get this moved along. I mean, we're either going to walk away from it and let it go for another 6 months or a year, or we're going to push it. And I was just wondering if we can continue this meeting for 2 weeks and set the meeting and have them show up. I don't know what kind of pressure we can put on them, but let's get it done.
I would note that in the Houston letter, he was adamant about receiving a prompt resolution back in 2010, and even went so far as to threaten a slap suit in the event that it was not speedily resolved. I would favor a 2-week continuance and have the parties present at that point in time. Yeah. That's the 18th? No, 16th. 15th. Do I have a motion to continue it for 2 weeks?
I move we continue 2 weeks to the 16th, but at the same time.
I second that motion.
Okay.
All right, all in favor? Aye. Okay, that coupled with the,
Make that motion on 10 also.
oh, all right. Yes, does your motion apply to
Yes.
item 10 as well? All right. All in favor?
Aye.
Aye.
Chair, does that mean you want the letter at that time, or do you want the letter before that time? The responsive letter? Just so staff can communicate to Mr. Steele.
We did not set a time limit on the filing of the petitioner's pleading. I'm satisfied to let it go, well, subject to other points of view, I'm satisfied to let it go over 2 weeks, and if he can file something ahead of time, we'd appreciate it. Okay? It's going to take some time to put together a response to Mr. Houston's letter, so the indications we have presently are that the matter is going to be settled, right?
That is my perception, yes.
But whatever settlement, as Mr. Becker has pointed out, is going to be a Pyrrhic victory for whoever it is. All right. Item 11. Review and adopt the Commission's revised operating policies. Direct staff and Commission to submit the revised operating policies to the Board of Supervisors. Any comments? I've read them, and they appear to me to be reasonable. I'll second it. All in favor? Number 12 is to ratify and adopt new updated commission forms. Any comments? Again, I've read them. Okay, motion?
Well, I just have a question. Anything unique? I mean, we've read over them. Anything that staff wants to tell us about them that's unique or special, or is this just...
The only uniqueness to this item is a actual new form, number 5, is the notification of filing of a report of a parent violation. Under the old ordinance, we do not have a mechanism, a formal mechanism per se, to forward a notification to differentiate between a formal complaint versus a report of a parent violation. So for consistencies and for the formality, we introduce the notification of filing of a report of a parent violation so that the respondent, the investigating attorneys, the initial complaint review attorneys will be able to differentiate whether it's a report of a parent versus a formal complaint. The ordinance stipulates that the clerk of elections can file a report of a parent violation, and that has been the means in the current cycle.
Okay.
And Chair, if I can, the ordinance amendment that happened that made the other changes added language that said that all reports of a parent violation, which weren't discussed in the ordinance before, are to be considered and treated as complaints. So when we got those in this cycle, Ms. Lee and I worked on using the complaint notification form and just revising the language to track that it's not a complaint, it's a report. In the past, the elections official has done both complaints and reports, but more recently they've been largely reports of parent violation. And as you see, those are 7 of the 9 items. So for the purposes Ms. Lee said, to differentiate and to make it clear to the initial complaint review attorney and the parties, we thought it should have its own form.
Okay.
Okay, sounds good.
What is the significance of, what is the difference between an alleged violation and an apparent violation?
Oh, there no difference, and it's apparent violation is the term used in the ordinance.
Okay, and...
But a complaint is different. That
Right,
is someone
and-
that's filed, it's a $35 fee, and that sets the parties as three. It makes it three parties to the action. When the elections official files a report, he's not involved anymore. It's just a report that's sent and it's processed, and it would eventually end up, if it's prosecuted, with the same investigating attorney, and it would be as if there were no other parties, just the two parties. But when you have a complaint, you have a third party involved, the person who's filed the complaint.
And the purpose of having a motion to make a motion, an apparent violation versus filing the complaint is what?
I think it was to give the elections official more discretion when they weren't sure and didn't want to file an actual complaint against someone when something appeared to be a violation, but your commission or the initial complaint review attorney might say, no, actually under the law that's not. It was just to give more discretion to the elections office.
But it's more discretion to file more reports, right?
Well, it's to not have to file a complaint. In other words, they can say, there may not be here enough to actually file a complaint against this party, but it's at least something that should be investigated because it appears to be a violation. And especially, for example, there are some reporting requirements where state law could trump the ordinance. And the elections office may see, well, this appears to violate the ordinance, but the initial complaint review attorney might look at it and say, but there's a state law provision that trumps that, therefore there is no violation, and it ends the matter on a lower keel. It's not as, I think a lot of this has to do with how these things are reported in the newspaper, especially during an election cycle, and I think there was a feeling that a formal complaint is a much more serious allegation than a simple report of an apparent violation, but I can't tell you more than that.
But the commission must approve either.
You must eventually act on either. That's right. And it's in the same manner, which is what the addition to the ordinance informed us all, because it says that you treat these reports as complaints for purposes of processing it. Before, it wasn't even clear whether they went to an initial complaint review attorney, whether they went to an investigating attorney. But staff had treated them that way for lack of a way to treat them otherwise. They had to come to you eventually with some kind of memorandum and report from an attorney who had reviewed them, and to keep that objective and third party and not from staff itself. If I'm advising you I should not be presenting an argument on either party's side, that was referred by staff to outside attorneys, and it was the same attorneys. And then the board codified that when they amended the ordinance and said, yes, treat the reports the same as you treat complaints.
Any other comments from staff on the changes suggested?
No comments.
Okay. Do I have a motion on approving them? Did we already do that? No. Okay. Second. All in favor?
Aye. A question, have they ever had a workshop on this, the board? I mean, we sit here and they sit there, and the folks in the audience, observe this process, but part of it may be just we aren't real active, at least we haven't been for the last year and a half. There haven't been a lot of complaints, but as a practical application of what we are doing, it reminds me almost of, I shouldn't make light of it, but a Woody Allen skit where, right at this point it's, just a notion, but with a few dollars we could come up maybe with a concept, and before you know it, we might have a real idea. We sort of ease into this an apparent violation. I'm wondering what the reasoning is, why the elections office is the kind of enforcer or what do you call it, sentinel point to make these observations, but not to make them complete, because I think sitting at home when you see that in the newspaper, an apparent violation, the average person doesn't probably distinguish between apparent violation and complaint. because neither have been confirmed as a violation of anything, and so it makes it a little easier for someone tactically or out of an abundance of caution say, well, I better say something about this even if it may turn out to be nothing. In the meantime, that has a lot of practical consequences during campaigns. So I'm just curious, has there been any kind of discussion at the board who has adopted all this about that?
There was discussions at the time of the amendments were made, and they did add in this last amendments two provisions in 1297 that actually are on the agenda in L&M. The commission shall meet at least once per general election cycle to review the administrative and financial efficiencies of administering the ordinance and shall make recommendations to the Board of Supervisors accordingly. And then M, the commission shall provide a report of its activities to the Board of Supervisors at least once every 2 years beginning this next January. And I think the purpose there was to get feedback from you on what changes may be appropriate. And that's in part why on the agenda later there's an opportunity for you to expand on what you want to report to them on these very issues.
Okay.
There's never been any formal workshop between your board
so
and
the procedure would be for us to, amongst ourselves, to give them the feedback on how this is starting to work or not work.
You could do that. You could even, under the Brown Act, agendize a joint meeting. There are many avenues you could take to do that, but there have not been historically anything more than these additions the board made the last time.
Okay. Well, based on a lack of experience and a heavy reliance on staff up to this point, I don't believe we've had those kind of discussions other than to react at the meeting on suggested changes. But there is starting to become an appearance of more of a feeding the beast or massaging the paperwork as opposed to, a little reminiscent of some of the experience we've had under the Brown Act. Everybody talks about the Brown Act, but I keep looking for an investigation that turns out to come in a timely way that does anything other than to say it either was inconclusive or don't do it again. So, okay, well, thank you.
Was part of your question directed at why the elections official is the person responsible for, or at least takes the role of recognizing apparent violations?
Well, it's a combination of that. It's wondering why they need to play that role rather than to react to complaints, because both parties in a campaign, or the many parties in a campaign, usually watch this stuff closely. And if they feel they either have a real complaint or a tactical advantage, they'll come and file it. And it seems like we're expanding the process, increasing the workload, splitting the hair a bit. I'm a non-legal person, so I may not know what I'm talking about here, but apparent violations versus complaints in a process that I've experienced thus far has not been a big distinction, except to give more latitude. And I'm just wondering if that latitude reduces workload and reduces the impact of maybe bogus complaints on candidates, then that seems to me to be a great idea. But if it just simply gives staff or the clerk, the elections office, the opportunity to say, this looks a little strange, maybe we better raise a flag and say there's an apparent violation, does that make any sense to you?
Yeah, it does. I assume that the elections office undertakes that task because they're the only neutral party who receives the filings of each of the claimants and reviews them. Now, either party may have an axe to grind and may file their own complaint, but the elections office is the neutral party, kind of overseeing what the filings look like and whether they're appropriate.
Well, I mean, it seems like you have to simplify things some fashion. You've got the elections department overseeing this. They see a problem. They see what they think is maybe a violation. How do you deal with that? They file a complaint every time they have a question, unless they have somebody to go to and say, is this really a violation? And it sounds to me like this report is simply a way of saying, wait a minute, I'm not sure about this. It's kind of like going to council and saying, is there a violation? Because that's what happens.
Right.
I assume the report goes to council, to investigative counsel, and he says there is no violation.
Okay, well, I guess maybe the first question I should have asked is with the apparent violation, Is that a somewhat confidential thing until it's been reviewed by the...
The elections office can discuss it with its counsel, which happens to be me also, and then issues the report to the CEO's office, which then, because of the ordinance amendment, treats it as if it were a complaint, and everything else flows from there. But initially, the elections office, as Mr. C said, is getting all these reports. They get all the disclosure forms that are required both under the ordinance and under state law that have to be filed with the counties, and they review them. And they would see, for example, the issues in the 7 that are for this new cycle and say, well, that looks like it was more than the ordinance allows. Like, for example, there was a $7,000 one, and the ordinance is a $700 limit at the most.
Okay, but
That appears like a violation.
Is that initially a somewhat privileged or confidential thing until it reaches the CEO where it
Not
becomes
that
a public
document.
record?
That document's a public record.
That's my
Anyone
point.
can see that. And in this case, there are duplications between the complaints that were filed and the reports. Both the elections office filed reports of violations that were included in a formal complaint that was filed by a third party. So there's an overlap. Both noticed the same problems or apparent problems in the filings.
The point I was driving at is at the point at which something becomes part of the public record and publicly known, if it's generated, by a neutral party, it has the same impact politically as a complaint, I would presume. At least if I read it in the paper, I would tend to think that way, unless I had special knowledge of how the esoteric nature of what we do. So that was kind of where I was wondering. The courts don't sit around as a neutral party and think these, say, I think maybe a law has been violated. They require parties to bring this before them and take responsibility, and they don't hear what moot points, except for practice and for the high schools. They require two sides of the issue to be sure that, kind of the truth is known. It just occurs to me that it's possible that these can be used if the threshold at which they are filed doesn't require thorough investigation. It's just like I say, what's the difference between apparent and alleged? So anyway, I've said what was on my mind. I don't know what we do with it, but
Well, from what we have reviewed as a committee or a commission, it doesn't seem that there is an overabundance of self-generated actions by the elections division. It's only been a couple.
how many did they say out of the 9 or whatever?
7 of the 9.
7 were generated from elections.
Right. For the current election cycle, we have a total of 9. Of the 9, we have 7 report of apparent violations and 2 formal complaints. Back in 2010 cycle, we have a total of 6. Of the 6, we have 3 reports of apparent violations.
And 3 complaints.
Okay. I take back my remarks.
But that was, I know this is probably not the forum to do it, but it does seem like that. It does seem like that part of the process we should be looking at maybe a little closer when we have stuff that's hanging around for a long while. Is one issue, and the other is how many of these get generated and to what value or to what harm.
What I might suggest is that you agendize for that meeting on the 16th, ask the elections official to come and discuss it with you, and maybe defer your report to the board to that time and add those in addition to what's in your agenda to your report to the board if you have comments. The report's not due till January, so you could have that kind of at least communication and conference with the elections official and anyone else you thought should come, a supervisor's aide or representatives. There's a lot of people you could ask to come.
Do we have a motion for that?
If that's the legal way in which we could have.
Well, if you want to agendize that matter, you would ask staff to reach out to all those people that you think would be helpful to have in that discussion.
So we continue item 13 for 2 weeks and ask that there be
staff
I
sufficient.
would like to have the discussion. I don't know who all those people would be, and I wouldn't want to take a lot of time of other people to do this. Maybe, someone from the elections office, and I don't know who else would be. Maybe a citizen who has interest in the process.
Well, the public would definitely be invited, and what I was thinking is that you might want to let each supervisor know in case they wanted to send someone.
So we need a motion to continue number 13 for 2 weeks and to request staff to agendize the matter for a presentation by the Elections Division.
To clarify, it's not 13, it's 15, and we're not there yet. 13 is just a receive and file. 15 is your report to the board.
Okay.
Oh, okay.
So we're going to continue 15 for 2 weeks and request,
Roberta's saying you're not at 15 yet.
We just jumped there. The chair just went there. Right?
Without objection.
rule of the chair, does that work?
That's the rule of the chair. Let's move this thing.
All right, we're going to handle 15 out of order.
Excellent idea.
All right. Do I have a motion on the continuance? Oh, and I'm sorry, the direction to staff to request that somebody from elections, a person of their choice, attend that meeting, and that staff notify each board member, Board of Supervisors member, of our intended action.
Okay, second, but with clarification, what we are doing is we're continuing the matter, we're agendizing the discussion amongst ourselves, plus those people who might have some interest in the subject or expertise. I guess from my standpoint, if this is known to the people who are affected by it, I presume they would show up and could help participate if we get it. The discussion, I think, amongst us with legal counsel is to just sort of figure out how does this really work in practice and listen to the clerk as to what benefits it is to the clerk. And then we weigh the advantages of what we're doing here, it seems. Okay. I've seconded.
Okay. All in favor?
Aye.
Aye. All right. I'm sorry. Oh, 15 we did. What happened to my card?
I know it's not appropriate for me to speak to this issue as a member of the public, but I am interested in the topic, and it seems to me just one observation is if the Elections Committee is filing an apparent violation, it seems to me that that carries a little more weight to me as a citizen than if somebody files a complaint. I filed a complaint. Don Becker filed one. And, you never know if Don Becker has an axe to grind, whereas if the Elections Office files a complaint or an apparent violation, then it seems like that person has no axe to grind, and that, so it seems to me it would carry more weight. But in addition to that, the real reason that I came up is in the complaint that I filed, I alleged 4 violations. And you said that the Election Commission or committee, the Elections Office lodged 7 apparent violations. Well, it may be that all 4 of the ones that I filed on are also things that they filed, or that they said that they alleged were, or that they say are possible problems. So it may be that there's a lot of overlap on these. So that ought to be examined too prior to your discussion when you have it.
Thank you for your comments. I assume that those are matters that the elections representative will address at the next meeting. All right, we're back to number 13, which is a receive and file. The Ethics Commission report prepared by your staff for the period of January 1st, 2011 through December 31st, 2011, and January 1st, 2012 through October 31st, 2012. Any discussion on number 13?
Presume this is just a formality to acknowledge we've received it. I so move.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Okay. Number 14, receive and file staff's report on the administrative and financial efficiencies of the Ventura County Campaign Finance Reform Ordinance pursuant to Ordinance Section 1297, Pren L.
Again, this is simply acknowledging that the report's been filed, not necessarily endorsing the efficiencies at this point.
Object to the Fonte matter?
Well, I'm looking at this financial, the report. I don't understand, fiscal year 2011, 12, commission's attorneys. Is that the investigative attorneys?
Both councils, the initial complaint and the investigating.
And there was no money spent in
Nope.
11, 12?
No money invoiced.
No money
No
invoiced.
money invoiced.
And that's where you have the inactivity on the two matters that are still pending.
Okay. Move we receive and file.
So, do I have a second?
Okay.
Any further discussion? All in favor?
Okay.
Okay. Number 16, public comment. We don't have any cards, is that correct? Mr. Becker's already spoken. Mr. Becker, did you have anything you wanted to add?
No, thank you.
Anything else?
Well, just a question to staff. We've continued this for 2 weeks. Sometime, I know there's a problem with a room in that. Is that cleared? I'd like to get that taken care of before we move on, before we leave.
Actually, Fridays, this room is pretty clear, but the only thing we can do is just take a short recess for me to call room reservations, and I can find out if you want to do that.
Okay, we're in recess.